IR35, also referred to as the intermediaries legislation, is a piece of tax avoidance legislation that was introduced in 2000. It was introduced to combat tax avoidance, and this tax avoidance was being made by individuals working through what HMRC referred to as a personal service company, a PSC, but essentially working the same as an employee, yet paying less tax. So this piece of legislation was introduced to make sure that that contractor determined their status correctly, and if they determined themselves as working inside of IR35, they had to pay the correct taxes. IR35 can't technically be avoided as it applies to all contractors that are supplying their services through a personal service company. However, what can be avoided is being caught by IR35. There are certain factors that need to be considered to determine an outside IR35 status determination, and this is based on historical case law. One of those factors being substitution. Does that contractor have a genuine right to substitute themselves, not just a contractual right? Would the client accept to substitute if they were equally as qualified as that contractor on that assignment? Mutuality of obligation. Is the client obliged to offer that contractor work, and is that contractor obliged to accept it? If so, that doesn't look good for an outside status determination. Control. How much control is that client exercising over what the contractor is doing and how they are working? Are they required to be there at the same time every day? Again, if so, that doesn't look good for an outside status determination. Financial risks. That contractor needs to be seen to be taking financial risks when working through a client on an outside status. Things such as business insurance, making sure that they're not being required to be paid at the same time every week, every month. There are a variety of factors that need to be considered, but ultimately that contractor needs to be able to prove that they are working in business on their own account. So historically, it's always been the responsibility of the contractor to determine their IR35 status, not the client and not the recruitment company. Back in 2017, this changed, and that responsibility shifted to the end engager. They were now the party that was responsible for making the determination if they were working inside or outside, and if they determined that they were working inside, they were then the party responsible for making any PAYE and necessary NIC deductions. Unless there is a recruiter in the chain, what HMRC referred to as the fee payer, then they would be the party responsible for making those determinations. Now, what's happening in April 2020 is those rules are being shifted as well into the private sector. However, they will not apply to small companies, and the current rules will exist for those. So in the private sector, from April 2020, the end user, the client that the contractor is working for, will now be responsible for deciding what the status of that contractor is, if they're working inside or outside the IR35 rules. A contractor can't make the client decide they are outside IR35. The new rules place that responsibility onto the client to make that determination. What they can do is talk to their clients, educate them on the way that they're being treated. If they really want to continue working outside of IR35, then they need to make sure that their working practices reflect what the contract says. Talking to their clients can mean that they can get to that outside determination if their clients can align the way that they are treating them with their contract. If they're not happy with the determination that the client suggested, then what's been proposed in the current consultation is a client-led status disagreement process, and that will allow the contractor to disagree with that status determination that has been made. But ultimately, the client is the one that will be responsible for making the status determination. The banking and finance sector does seem to be very concerned around the proposed changes to IR35. Essentially, this is probably because the levels of control, the lack of ability to substitute, and the fact that it is a highly regulated sector. However, we need to understand that that doesn't mean that contractors working in the financial industry cannot remain working outside of IR35. HMRC have proposed that they believe 1 in 3 contractors are caught. Therefore, we need to make sure that there are no blanket decisions being made. What we saw happen in the public sector is the NHS do a U-turn on their decision when they said they were going to deem everybody as inside of IR35 or simply not engage with limited company contractors anymore. What we need to do is avoid any knee-jerk reactions being made. We've seen some recent press around a big name saying that they are going to cull their contractor workforce towards the end of this year. We need to avoid that happening because it could be a real damage to their contingent labour workforce. It's hard to predict exactly what the financial services industry is going to do and if they will continue to engage with limited companies. But the more we can do between now and April 2020 to educate clients and make sure that they start to review their working practices to avoid any knee-jerk reactions being made, the better. We need to ensure that contractors who are working outside of IR35 today can continue working outside of IR35 come April 2020. Yes, all contractors who are working outside of IR35 should have a substitution clause in their contract. However, most importantly, this substitution clause needs to be a genuine right. That doesn't mean to say that the contractor has to have substituted themselves before, but it must be a genuine right that they are able to substitute themselves should they need to. Therefore, if they found someone as equally as qualified, the client would accept them to replace them on that assignment should they need to. Role-based decisions are a tricky subject. Ultimately, if contractors working in the same role have the same working practices, then there is no reason why they shouldn't have the same status determination. However, there may be some differences between two contractors working on the same role. So my personal recommendation is that contractors should be individually assessed on an assignment by assignment basis. However, commercially, we understand that some clients will be making role-based decisions, which ultimately may be fine. What we need to make sure is that blanket decisions aren't made, and that is the difference between a blanket decision and a role-based decision. A blanket decision being giving all the same determinations for a number of contractors, as opposed to looking at the roles, looking at the working practices, and categorising them as an inside role and an outside role. Contractors can use the CESS tool that HMRC have put together. When you first go onto the CESS tool, it gives you the ability to either go in as the contractor, the client, or the agency in the chain. Ultimately, that decision sits with the client. So it realistically should be the client that is making that status determination. However, clients probably need some assistance from their contractors to come to those decisions. So yes, the contractor can use the CESS test to help their clients get to that end status determination. Contractors will have a few options if they are determined to be working inside of IR35. One of them is definitely the option of working through an umbrella company. Alternatively, they can work on a PAYE basis, or they could work under the deemed model, which is where they would still be working through their limited company, but they would have taxes and NICs deducted. Now, the difference is they need to make sure that whichever company they're working for, whether that's through a recruitment company or directly for the end engager, they have the ability to process payments on a PAYE or a deemed model basis. So therefore, it might be that an umbrella is the only option if that end engager or recruitment company doesn't have a PAYE or deemed model process in place. There will be a significant financial impact on a contractor compared to working on an outside IR35 basis through their limited company compared to working on a PAYE or umbrella model basis. That significant difference is obviously the tax take home. Ultimately, when they're working through their PSC, they will be taking some of their money through dividends and therefore paying less taxes as they would if they were an employee. Contractors should speak to their accountants to get a clear breakdown on exactly what those cost implications look like. A contractor's IR35 status should be assessed before the assignment takes place, but also if any changes are made to their working practices. So clients really need to consider this. If after they've been there for 3, 6, 9 months, if there are any changes to the way that they are treating them, then they do need to reassess that status. Contractors really need to take a proactive approach in relation to the changes that are coming in April 2020. Although that responsibility is shifting to the end engager, that can still cause significant issues for the contractor, and that's purely down to a lack of understanding and a lack of education to the clients and essentially potentially a recruiter in the chain. So what contractors should be doing now is talking to their clients, talking to their recruitment companies, find out what their approach is come April 2020 so they can decide exactly what they want to do when the changes are implemented. Contractors should definitely start to speak to their accountants to find out the implications and what that impact might look like to their take-home pay if they're going to be determined as working inside of IR35. They don't necessarily need to be taking legal advice, as it is now the client that is responsible for making those status determinations. But there's definitely some accountancy advice they can take to be able to see a breakdown of what those cost implications might look like if they are deemed to be working inside of IR35.